If you don't plan, you're stupid.
Hello and welcome back to If You Don't Plan, You're Stupid with Florida estate planning attorney Andy Rosenberg. Andy helps families protect their legacy, avoid probate, and make sure their wishes are carried out. My name is Kevin Rosenquist. Last time we did an episode on long-term care and nursing home costs and how to protect your assets. And there's a lot of information here. So Andy and I were talking and we said, let's just go ahead and do a part 2 to make sure that we don't miss anything. So that's what we're doing today. This is part 2 to the nursing home and long-term care costs. Andy, welcome back.
Thank you. As they say in the beer commercials, this is dose.
Dose. Go for dose.
Yes, we're doing dose here. Here we go. The second one. Yeah, so Kevin, I know we talked about a lot of stuff on the first part of the Medicaid. So let's just recap it real quick.
Sure.
If you have more than $2,000, I'm talking about an individual. If you have more than $2,000 of assets or more than $2,901 gross income per month, you will not qualify for Medicaid in the state of Florida for long-term care, assisted living care, or home health care. And we talked about the three-legged stool. You have to have medical necessity, and then you have to be below that income limit we just talked about and below the asset limit we just talked about. So that's kind of where we were at. So the question is, how do we handle all this stuff? And so that's what we were talking about.
Yeah, we got into the Medicaid trust, and then you talked about the I forgot what the term was for the to get the money out that you don't get to keep afterwards.
Oh yeah, so we talked about two things. We talked about if you have assets that are over the $2,000 total. One of many things we do, but majority of the time, we're going to create that thing called a personal service contract. And I'd like to talk further about that. About that, if you don't mind.
No, let's unpack that more.
Okay, and then the other thing, which is what you were asking, if we have over the income limit, we set something up called a qualified income trust, which is an irrevocable trust, but it's also called a Miller trust. So it's the same thing, but that's just the term it's either called a QIT or Miller trust. But I want to go back to the if you're over the income limit.
Okay.
Or not, I'm sorry, the asset limit. The asset limit. Yep. And we got that personal service contract. So there's a lot of issues here that I want you to be aware of. And there's no right or wrong answer. It's kind of a gray area for this with the tax issues. And that's what I wanted to talk about. We didn't get into it in our prior part 1. So again, we talked about your mom. She had $300,000 of assets, and we did a personal service contract, and we were able to move all that assets into the personal service contract, which now is yours, because the personal service contract is an agreement between your mom and you that you're going to help take care of mom and supervise her accounting work and her house and just do all the normal things you do as a kid. And then in return, she signed that personal service contract and moved that money over so that you could use some of that money for that purpose. So that's it. Now, but here's the issue. When we move the $300,000 over to you, and then you put it into a separate account or whatever, technically this is where the tax issue, that could be considered income to you, that $300,000, or it may not be considered income to you. It depends on your CPA and how they want to decide what to do. I like to err on the side of conservative on this, and I think it's income. So when you get that money, it's technically not a gift, it's income to you. You're giving money to take care of somebody. So that's a big hit for you, Kevin. Now let's just say you're making $50,000 a year, and now all of a sudden you get a $300,000 hit. You're now pushed into the largest tax bracket. You're going to have a huge tax. So one of the things that we do, at least our office does, instead of you getting all that money at once, we have your mom write the check instead to you, not to you, but instead to an escrow. We create an escrow account for your mom and you. And the money goes into escrow. It's out of your mom's hands, so it's not part of her estate to qualify. But it also, you didn't get it yet. So you don't have a tax issue. And then let's say you need $10,000 this year for things that you need to spend on mom. We give you money from the escrow account. Now you have $5,000 to $10,000. That's going to be included in your income for that year, right? But the other $290,000 is not. Then let's say we do that, so it helps minimize that tax on the kid who's taking care of mom or dad. And then what happens is when mom dies, you don't lose that money. That money now goes to you free and clear, estate tax free. So that's a way, if you're concerned about tax issues, how we can deal with that.
Mm-hmm.
Did that make any sense?
Definitely. Yeah. No, that's yeah. Cause you're right. I mean, if you get all of a sudden you just get this influx of $300,000. Yeah. I mean, that definitely changes. It's great. I mean, I suppose, but it changes your tax situation. So yeah.
Yeah, for sure. So that's dealing with an asset side. Now let's talk about some assets for a second. Biggest asset everyone is concerned about is the house, right? So mom has the house. She's in there living in it. Are they going to take the house away from her? Does that count towards Medicaid qualification? In Florida, generally, the house is exempt. It's not counted for Medicaid purposes. However, Florida will go after assets when mom dies. Florida will go after assets that go into probate court. So if the house is in her name and it has to go through, and she dies and it goes through probate court, they could try to come after some of the money they paid out, every month for mom, to come after the house for that. So one of the best things that we do is, and we've talked, I don't know if we talked about it yet in a prior podcast, we do something called a ladybird deed. There's only 5 states.
I don't remember that.
Okay. I think we'll probably do a podcast on that. Note that for everybody that we got to do a podcast just on that.
Okay.
But there's only 5 states in the country that allow it, and Florida's one of them. And it's a special deed where we transfer the property from mom to mom. So mom still owns it. She could sell it. She could do whatever she wants with it. Still her homestead. However, when she passes away, the deed names a beneficiary, names you, Kevin, as the beneficiary, and it will automatically go to you, and there's no probate court. By doing that, we have taken the house totally away from Medicaid, and they will not be able to ever come after it.
Wow, that's big.
Yeah.
That's
so
big.
It's interesting. Yeah. So I know we're getting in a little bit of minutia here, but it's kind of important because everyone asks that question.
Well, that's a big question too, because I mean, especially with how much houses are worth these days, I mean, that's like a humongous asset for people. So yeah, it's a natural thing to be concerned about losing that.
Yeah. Yeah. So that's a little bit about the asset side. Let's switch quickly again and try to explain that income portion where you have to have less than the $2,901 a month. It is a gross number, guys. So if someone gets Social Security of $2,800, $2,600, $2,000 a month, that is not the gross number. That's the net number you're seeing in your account. It's going to be a couple $100 more probably. So that's why it's important to know what your numbers are, because you think it might be below $2,900 when we count your pension and IRA distributions and all that. All counts, by the way. If you're in required minimum distributions, you're over the age and you have to take out every month from your IRA, that income coming from the IRA is counted as income. So if you count your pensions, your Social Security, your required minimum distributions, and all the other sources, you can quickly get over that $2,901 a month. So that's where that QIT or Miller Trust comes in, and we put it's an irrevocable trust, and then a bank account is open, and we put it in there, and then every month the difference, you take whatever the difference is to make you below the $2,901, and it goes in there every month. And then Kevin, you have access to it, and then you can spend the money, and I recommend that you spend the money on a monthly basis for mom's needs, as long as it's allowable. And here's why. The difference between that personal service contract and the QIT, the personal service contract, that's your money. You'll never lose that. The QIT or Miller Trust, whatever's in that account when mom dies, you lose all of it. That is automatically going to the state of Florida for reimbursement. So why would we want to build that up to tens of thousands of dollars or whatever it might be, right? Or hundreds of dollars, whatever it is. You don't want to build that up because who cares? It's going to the state.
Right.
So I'd rather see you spend money from there first for use of things than touch the personal service contract money.
Okay. That makes, I was going to ask about that as far as how you can use that. Is there like a certain amount you can spend per month or something like that on the Miller?
No, you can spend whatever you want as long as it's, I mean, you got to go through. Is it for mom? Is it for medical necessities? Is it for toiletry stuff? Is it for diapers? Is it for food? Is it for medical care? All that stuff's allowable. But I mean, you can't go. I mean, maybe you could. You might be on the fringe here. Spending money to have mom go on a trip to visit the kids, that might be allowable too.
Yeah.
Grandkids. I don't know. I'd have to look into it. But the point is, you want to use it. You don't want to keep it.
So you're saying I should not use it to buy a car for myself?
I don't think that will work. No.
Okay.
But speaking of cars, that is also an exempt asset. And so one of the things that we do, here's a little trick of the trade. If mom's got a beat up old 20-year-old car, right? And she's over the asset limit, well, guess what? Sell the car and let's go buy a fancy car. It could be $100,000 car. There's no dollar limit on the car. You could buy a Ferrari and it's exempt. Is that crazy or what?
Now I'm thinking. All right.
It's crazy, but it's true.
That is pretty wild that you could buy a Ferrari and it's exempt.
Right. But it is. So, I mean, there's lots of things that you deal with. Now, the gifting we talked about as well, it gets very confusing. So just be aware that there is a 5-year rule. And if there was gifting involved, we still have to deal with that. Okay. So if mom gifted to the grandkids and then 2 years ago, they're going to look back 5 years. So I still have, and it's not in the account and she doesn't have any more money. That's still a problem, right? She's below the 2,000 at this point, but she gifted out $25,000-$30,000. They're going to claw that back in. So we're going to have to deal with that. So there's lots of things and intricate details that we have to deal with when it comes to getting someone technically qualified for Medicaid.
When you do this, because we talked last episode about people who plan and people who are or crisis or who go into crisis Medicaid planning. Does you mentioned the 5-year look back. If someone comes in, if someone plans ahead and goes to you and you do all this stuff, you make the whether it's the Miller Trust or the contracts or whatever it is.
Remember that stuff's more on a crisis Medicaid.
That's more of a crisis. Yes, that's correct. Okay, that's right. If you do the other stuff as far as planning, is it still 5 years that they have to look back in that scenario?
Yeah.
Okay, so even if you've done all that planning and
that is a strict 5-year rule.
Okay, that is a strict 5-year rule. Okay, got it.
Yeah, but let me talk. Let's talk about some of the legal. We've been talking about legal documents, obviously. One of the things that people get concerned about is, well, you know what, mom or dad's kind of got dementia, and I don't know if they're able to sign things and do things. So how are they going to sign the personal service contract and all this other stuff? So very important documents to have in part when I do Medicaid planning, and we're talking about elder care planning, not the estate planning, Kevin, not the revocable trust and all that stuff, but just getting someone to get able to qualify. We a lot of times we have to deal with the deed. We talked about the Ladybird deed, right? We might have to do a Miller Trust, that QIT. We might have to do a personal service contract and some other things. But just as important and almost vitally important is to have a proper durable power of attorney and a proper healthcare surrogate form for mom or dad. And a lot of times people say, I got it. We have the durable power. We have the healthcare surrogate for mom already. I said, well, send them to me. I want to see it. And then I get the durable power of attorney, Kevin, and it's 2 pages. And it's just a generic durable power. There's so much crap out there as far as the good and bad durable powers of attorney that would not hold up in a Medicaid analysis done by the state. Meaning, if I said, "Look, Kevin, we need to do crisis planning, we need to do that qualified income trust, we need to do personal service and some other things," and then we see that mom's not able to handle things and that you're her power of attorney and you're signing this stuff as power of attorney, okay, for her, right? You understand that?
Yeah.
So if she can't sign, you're doing it for her as the power of attorney because you have the authority. If that power of attorney is not a good one, it will cause a lot of problems. So one of the first things that I look at when I meet with clients, and then I do an analysis and everything else, and then I say, okay, let me see your documents. If there's not the proper language in the documents for the durable power, we need to do a new durable power.
Wow.
Yeah. Give you an example. My durable powers on average are about 35 pages in length. They're huge. Wow. In Florida, they require us to have the person affirmatively initial certain powers that they give us, that they allow you as the son to do. So some of the documentation that we need to have in there is we need to have language in there that says, I can create that personal service contract, I can create the qualified income trust or other Medicaid friendly documents that need to be created. If it's not affirmatively said in the durable power, it will probably not hold up under Medicaid analysis.
Mm-hmm.
That's why it's really important that we see that. So I actually have to create Medicaid-friendly durable powers of attorney and Medicaid-friendly healthcare surrogates for healthcare decision-making, as well as part of the analysis when we're doing all these other documents probably. And I know if mom and dad, listen, if they're mentally, if they got this, you've heard of this sundown dementia?
No.
Okay. So I just had this today with someone. So a lot of times what happens is mom or dad has early stages of dementia and they're fine during the day. And then as the night wears on, they start to get bad. Right? It's called sundown dementia.
I didn't know that was the thing.
Yeah, it's very common. Very common. I don't care if the person has that, as long as the person is signing the durable power and we're able to see that they understand what they're doing and signing and who they're giving it to. As long as they understand it when they're signing it, it's valid.
Mm-hmm.
So that's really important, because if we have a valid durable power, you as the son, who's probably in charge as the attorney in fact, or the durable power, you can then create that personal service contract. You could then create the Miller Trust and do all these other things if mom's no longer able to.
Okay. All right. Yeah. Wow. Yeah, that's big.
Yeah, it's huge.
Yeah.
It's huge. Yeah. I know this is not the most exciting stuff, but
no, I think it's interesting. I mean, I joked last episode, because I'm like, well, it's interesting to me because I have 2 aging parents, but I do think that like anybody who might, I mean, we're all gonna get old. I mean, ideally, and so it's good to know this stuff for when you plan for your kids too. I mean, just to be able to have all this information.
Yeah, for sure. So, I know we're running out of time again, and I think we're done with this. I think we beat
no part 3.
Yeah, no part 3. But if I had to bring it all together and summarize it,
okay.
Here's what I think you need to do. Number 1, the best form of protection for nursing home, assisted living, home healthcare is long-term care insurance. Long-term care insurance is becoming extremely unaffordable, so you may not be able to get that. If you can't afford it, you can't do it, then we got to worry about, well, how do we qualify for Medicaid when the time comes? Because we really don't want to have all our assets and our income get dwindled down to nothing to the state of Florida. We worked all life for this whole thing. So what do? Well, if we're proactive, we set up an irrevocable trust and we move assets in there and we hope nothing happens over the 5-year period. But you don't have to do that. In fact, I don't necessarily recommend that in Florida because Florida's so crisis Medicaid compliant. So I just tell people, let's make sure we have your estate plan in order and make sure we have a good durable power in order, all that stuff. And then when the time comes, contact me, and then we could do the crisis Medicaid planning.
Yeah.
And that's that personal service contract. That's the Miller Trust, the QIT Trust. That's all these things we've talked about, the gifting issues, you name it. So it all counts. But that's kind of in a nutshell how all this works. So you need to understand Medicaid planning is not the same thing as estate planning.
Right. That was my confusion in the first episode. So that's important.
Yeah. So and remember that Medicaid planning for mom, dad, brother, sister, whoever you need it, it's a three-legged stool. We got to deal with the Medicaid application process. We got to deal with the income limits and the asset limits. And I'm done. I'll let you finish it up and close us out.
Mic drop, Andy out. All right. Well, thanks for joining us for part 2 on our nursing home and long-term care. I hope you found this interesting. I know I did. It's really important stuff. If you know of anybody who could use this information, please share it with them because Andy's great at what he does and he wants to help you protect your assets. Visit rosenberglawfirm.net to connect with Andy, get some more information. And please subscribe to our channel. And like I said, share this with anybody you think could use it because it's valuable information for sure. Andy, thanks so much. Always great chatting with you.
It's always good talking, Kevin. Have a great one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.